Well, thank you. Well, let me begin by thanking the organizers for giving me an opportunity to present my thoughts and perspective from here in London. Although Rio would have not been such a bad idea. I do have a presentation for this talk. I shall now share my screen and request someone to just confirm if this is visible to you. Right, I can't hear, but I'll presume it is. Splendid. Right, so I'll just jump right into this. The first topic that I'd like to discuss in respect to this presentation talks about the International Court of Justice, followed by a brief discussion on the International Tribunal for the Law of the Sea, and then the Inter-American Courts to round off. But I promise that I will not discuss cases which my worthy colleagues on this panel are discussing. So to begin with, we look at the International Court of Justice, and there's quite an intentional choosing of this photograph, as I will discuss in parts of this paper. Of course, we're all aware of the jurisdiction of the court and also its responsibility in giving advisory opinions, especially firstly in regards to the legality of the threat of use of nuclear weapons, which initially was brought to the court's attention by the World Health Organization, therefore creating some sort of a link between human rights, the right to health, and also the other rights, such as environmental rights, which is the core of this talks and also this discussion's theme. But the broader issues that need to be discussed, especially in regards to the latest request to the court, must address and articulate the inequalities and the desperation between the challenges that the court faces in regards to climate change litigation. The court must, in its new responsibility with the advisory request, address the issues of climate litigation and the complex interplay between environmental justice but also economic development, a balance which is often skewed for less developed countries. Therefore, in this respect, common but different responsibilities becomes the beating heart of the issue. This principle, of course, is known to everyone on this panel and in the audience, is enshrined in the UNFCCC. But a TWAIL analysis of this requests that an advisory opinion, if it fails to robustly integrate this responsibility, will be overlooking disproportionately burdening the climate change responsibility on global South states. Reparations and liabilities in the climate litigation space is also something that requires a TWAIL perspective. The historical responsibilities of industrialized nations in contributing to climate change litigation and demands for a legal framework to operationalize reparations is something that the court can look at in its obiter dicta. The ICJ's advisory opinion must scrutinize and address the intersectionality of climate change litigation with human rights and indigenous rights, as I will look at in the issues of the Inter-American Court's successful litigation in this respect. This also recognizes the interconnectedness of various forms of oppression which the TWAIL scholars, such as those who I will refer to shortly, speak about. The advisory opinion must also study the intersectional issues and the aspects of the accessibility to justice and the long-standing participation of non-state actors, as the court has been able to look at. One issue that the court must stay away from is creating a Western Sahara advisory opinion situation where large parts of the General Assembly were drawn further and further away from looking at the court as an ideal of quote-unquote justice. The trends that the court has adopted through Chagos and the other cases that it is now going to deal with, especially in the new case brought by the ILO, reflects a perpetuation of a new stance that the court can adopt further and further away from the neo-colonial and the neo-imperial perspectives that it has been so infamously known for in the recent past. In some sense, or in some sort of conclusion or a summary of this, the new cases that the court deals with, especially reflecting from Chagos and the nuclear weapons case on one hand, whereas the Western Sahara case on the other hand, is the recognition of self-determination of states and the importance of completing not only decolonization but also empowerment through the law. I think that remains the most seminal part that the court can play as the primary judicial organ of the United Nations. A specialized court in the system and the mechanism of the International Tribunal for the Law of the Sea, which was established in 1982 through the United Nations Convention on the Law of the Sea, plays a pivotal role and a mechanism for addressing maritime issues. Articles 286 and 287 of the court provide this legal framework for a peaceful resolution for the states. But more broadly defined within the jurisdiction of the court is Article 288(1), which endows a comprehensive authority to adjudicate disputes between the convention, marking a significant rise and also litigation on such issues. Of course, the International Court of Justice has looked at cases of maritime significance, but there is a specialized court, and someone you see on your screen, Judge Dunker, has written famously on the court as far as back as a decade, when he emphasized the role of the court as facilitating an equitable and effective dispute resolution mechanism, which is crucial for ocean governance. Of course, in this regard, the High Seas Treaty also becomes an important framework that the court must look at in the near future. Of course, the court is also looking at this in an advisory position, and also through its contentious litigation in the Ghana Cote d'Ivoire case, which is case number 23. The case is significant for the treatment of the equidistance principle of maritime delimitation, but also looks at the other aspects, wherein it looks at the legality of unilateral hydrocarbon activities in the disputed maritime areas. By doing so, the court has to look at issues of the jurisdiction of the court, but also to discuss the alleged violations under Article 88(3) of the United Nations Convention on the Law of the Sea, specifically in regards to the forum prorogation and also the inconsistencies between the provisional measures which are issued, but also the persuasiveness of the judgment. Of course, other scholars such as R.P. Anand and my former professor, Professor B.S. Chimney, have emphasized the role of the court to the principle of equity, not only in terms of maritime delimitation, but also in terms of the historical and socio-economic realities of those less developed states. Professor Chimney has also emphasized in International Law and World Order, which is something that he published in 2017, is that a more equitable approach to the ITLOS, suggesting that it should consider the historical and also socio-economic legalities of the countries, requires further study and deeper understanding. The last good that this paper tries to study is the Inter-American courts and the evolving role of the indigenous communities and their rights in environmental justices, and also the intricacies of handling land rights, development impacts, and also the evaluation of these aspects through a TWAIL perspective. The court highlights the pivotal role in the developing jurisprudence, but not also recognizing the specific rights, but also integrates them within their unique cultures, social and economic needs. There are a few cases that I think are on the slides. Unfortunately, they are not on the slides, but I should try my level best to mention them in the chat box. But only to suggest the Sumo case versus Nicaragua, and also the indigenous peoples of Saracu versus Ecuador. The court sets the precedence of acknowledging indigenous land rights and the requirement of prior consultation before taking projects on these lands. The other rulings also reflect the jurisprudential shift in inclusive practice of ancestral grants and also the right to a healthy environment to these communities. These cases often involve complex assessment of rights and violations, but also looks at the indigenous communities and showcasing the intersectionality of human rights, but also the cultures that are being impacted. But what becomes important is the discussion that takes place in the Sharmaka people versus Suriname case, where the court emphasizes the state's duty to obtain free, prior, and informed consent of the indigenous communities before developmental projects go ahead. This case also highlights the nuanced approach of balancing state responsibilities, but also the community, the rights and obligations towards the communities and their self-determination, which are also pivotal aspects which align with the TWAIL perspective. However, a more comparative analysis of these cases, but also of the courts, highlights something that was discussed in 2000 itself in this very forum of the American Society of International Law by a famous TWAIL scholar, Professor Mutua, who highlights that the Eurocentric roots of such institutions are primarily the beating heart of concerns for TWAIL, which seeks to unearth these challenges and underlying biases, specifically in regards to the International Court of Justice, which now seems to be overturning its colonial roots and also the oppressive practices it has, but is also driven by the states which are bringing matters to it, therefore dictating the practice of the court. Whereas in regards to something like the ITLOS, which focuses on maritime law, this confronts the different challenges to TWAIL, but also issues of environmental justice, such as equitable distribution of maritime resources, and also resources those in the global south, and a distribution of these resources within the global south. The Inter-American Court of Human Rights also highlights the potentiality which aligns more closely with the objectives of TWAIL, as is noted by Professor Diana Shelton, that the geopolitical dynamics often impedes the effectiveness of human rights institutions per se, with powerful states resisting accountability. And of course, this becomes true for all sorts of human rights institutions and organizations within the United Nations, but also beyond it. But for a TWAIL perspective, the integration of these principles into the institutions and regimes requires a significant reform. These are not just my thoughts, but also thoughts which are aligned more closely with Professor Anthony Ange, who points out that the necessity of deconstructing colonial legacies is embedded in international law to create a more equitable legal order. This means that advocating for reforms that ensure the equitable distribution, but also representation and the address of global issues such as economic inequality and historical injustices. Advisory opinions in this regard can play a seminal role, as I've discussed, not only in distributing the resources, but also the alignment of resources for past wrongs through reparations. These opinions, therefore, are instrumental for marginalized communities as they bring their issues to the international legal discourse, and that aligns with the objectives of TWAILs of global justice and equity. In conclusion, one can say that the dependence on the capacity to transform and incorporate these principles of justice and inclusivity are those which require further study and understanding. The role of international institutions, such as those which this paper and also the others will discuss, is to facilitate this evolution towards a more justiciable system. Parting thoughts in this regard, what one can say is that the core of the transformation needs to be recognized through the deep historical inaccuracies and also inequities, and the need for systemic overhaul of these international legal structures, not only through the discourse of scholarly debates, but also within the institutions, such as giving opportunities to those who come from such different perspectives, therefore widening the aspects, the reach of these courts, as has been noted by Balakrishnan Rajagopal of MIT, that highlighting the need for international law to move beyond mere state sovereignty and embrace a more holistic understanding of global justice is something that accounts for the realities of marginalized communities and also of the environment. Finally, the potential for a more equitable legal framework is in line with those 12 perspectives and democratization of the international legal process. This, as I have said earlier in this discussion, is that the greater representation for developing countries and international legal institutions, but also a more participatory approach that includes voices from civil society, indigenous groups, and the marginalized communities, will provide a more inclusive and a vital system wherein the international legal order truly becomes international. In essence, one can conclude that these key findings and their implications offer some sort of a roadmap or a structure wherein a more inclusive and a more equitable legal framework can at least be imagined. And therefore, in this exercise of reimagination, one requires deeper and much more inclusive study. And to tie these perspectives all together, one can look at climate change and the role of these international courts and tribunals, irrespective of the fact of it being in a system of advisory opinions or contentious cases, offers international courts and tribunals in some sense to redeem themselves of the historical inaccuracies that they have perpetuated actively or passively. With that rather optimistic thought, I shall now conclude, seeing that I am at 14 minutes. I once again thank the organizers for giving me an opportunity to share my perspective, and I look forward to the comments immensely. Thank you.